Good afternoon, everyone. I think we'll kick off, and I can see there's still people joining. So you're all very welcome this afternoon. For any that don't know me, my name is Zara Duffy and I am Head of Northern Ireland for Chartered Accountants Ireland. And I'm delighted to welcome you all here for our session today, where we're going to look at Brexit, the opportunities, threats, challenges and enforcement, but from a legal perspective. A few housekeeping points just before we begin. The presentation will last for around 40 minutes, which will give us plenty of time for questions and answers at the end. If you'd like to ask a question, if you post them within the Q&A button down at the bottom, and we'll keep an eye on them. And if it's relevant to the topic that is being spoken about, we'll maybe address them at the time, or we can move to them at the end. Today's session is being recorded and we will make the recording available to you along with the slides shortly after the end of the session. A&L Goodbody are our legal partner in the Ulster Society, and over the past 12 months they have been very supportive in providing us with webinars covering a whole range of topics, from Brexit to the various government support packages, and a couple of weeks ago we looked at sustainability within the charity sector. It's a partnership that we really value, and we hope that you as members find both informative and useful. And just to note that the earlier sessions that we have done are all available as recordings, and they're up on our Ulster Society website. If you've any problem finding them, just let us know. So I'd like to introduce you to today's speakers. We have Mark Thompson, who is the partner in the corporate team heading up commercial and technology law in Belfast. He advises clients on corporate and commercial law, governance and strategic matters, with particular expertise in the healthcare, energy and technology sectors. Mark has been on the wider firm's Brexit team since before the referendum, and he leads the Brexit group in Belfast. And Mark is currently chairman of the Belfast office. Micaela Diver is partner in the litigation team and heads up public and regulatory law in Belfast. She advises clients on competition law, state aid, procurement, and regulatory and compliance advice. She represents commercial clients asserting their rights before the courts in Northern Ireland on complex areas of law involving public law considerations. And finally, Johnny Hacking is an associate in the commercial team also, and he has responsibility for advising clients on a wide variety of commercial agreements, as well as complex intellectual property and data protection matters. Johnny has worked with a number of clients on their preparations for Brexit and is currently instructed on a number of client reviews analysing how businesses can adapt to the changes brought about by the end of the transition period and the implementation of the protocol. So Mark, Micaela and Johnny, you're all very welcome, and I will now hand over to you for your presentation.
Thank you very much, Sarah. Thank you for that fulsome introduction. And everybody, good afternoon to all of you. Thank you for joining us. We're very glad to have the opportunity to talk to you today about Brexit and what the consequences are for our clients. I think Johnny is going to load up the slides now. And our approach is for the day really to give you initially some background. Then we will talk to what we think are the key noting points from the arrangements that have come into play as of 1st of January. And then we will sort of try to apply, we're going to do triple header at the end, where we're going to look at the opportunities and threats that the position poses. And in particular, things your clients might want to be thinking about in terms of dealing with this. Again, on the agenda, you'll say, so Johnny's going to talk to goods and services initially, and then people issues that connect with those. Micaela's going to talk about competition and antitrust, which is an emerging area. I think historically in Northern Ireland, competition may not have been such a big issue, but we think it will be much more important in the new dispensation. And then Johnny will close off some points arising out of intellectual property and data. But before we get into the nuts and bolts of the position, I'll maybe just give us a bit of a general introduction. So press was my first observation, and unless you've been locked away in your house for say 2.5 months, you couldn't have possibly escaped the level of press around Brexit and its implementation. Well, hang on, we have all been locked up, haven't we? So maybe that's given us more time to consider what's actually happened. A lot of negative press, if we're absolutely honest about it. And I think if you look at the GB press, the left of centre press, much more vocal and much more dramatic in their approach. and we've all seen the stories about rotting pork in Amsterdam or carrots stuck in Liverpool. We've also seen press around our EU neighbours courting corporate emigration. So an awful lot of coverage around this. Obviously, we got the free trade agreement sort of settled just before Christmas. Presented us a very big win, which I think for people in GB definitely was. But perhaps a couple of years too late for businesses to prepare properly. So there are consequences. If you look at the customs environment now, there's a lot of noise around that. Businesses have been left with very little time to prepare for what are complex and new arrangements. It was going to be hard anyway, but given the way the timings worked, really we found that most clients are struggling to just get their heads around what's required. And I think a lot of the clarification that had been expected and hoped for from the joint committee on the protocol wasn't forthcoming, because the people who are going to be on that committee were also in the deal team negotiating the agreement. So they really only just got into gear in January in terms of trying to work out how things will work east-west. Health checks then, the sanitary and phytosanitary checks on agri-food products coming from GB into NI are obviously causing logistical issues at the minute. There's obviously always going to be an bedding in period, but we anticipate lasting impact on supply chains. Again, the best story I saw on this was delivery stuck in Dublin, where the manifest referenced drumsticks and eggs, and there was no agri-food health paperwork with it. It turned out the drumsticks were a bread-based Swizzler product, and the eggs were Easter eggs, but that cost 2 weeks of time to try to get those released because of the presumption that they did have agri products in them. Over to your space, and if we look at VAT, clearly I think that's a very quick and immediate impact for people selling goods into Europe, whilst the FTA does allow you to have tariff-free transfers. The VAT impact to our mind seems to have been missed very much so. Whilst there are workarounds that seem to be costly, so we'll look at some of those a little later. And my final point is just to quote that well-versed phrase, Brexit means Brexit. Despite all the panic, despite all the noise, what's happening is pretty much what was expected, I think, by most parties when the implementation period was going to close. The lack of preparedness, I think, has been caused largely by the timings, as I've said. But I would urge us all to be mindful that the most negative and vociferous kind of press coverage is coming from the GB press. So this is really, really tough for businesses headquartered and operating in GB with a European footprint. And we're not hearing that much about the NI protocol because we're not that important in the scheme of things with the GB press. So the protocol is very important for businesses in Northern Ireland. And I think, again, when you're talking to your clients, it's worth emphasizing to them, yes, there's negative press, but they really need to get their heads around what the protocol does for them, particularly if they're in the manufacturing or agricultural sectors. I'm now going to pass you over to Johnny and Micaela, who are going to talk through the key takeaway points, I think, in respect of the protocol and the free trade agreement as they affect us. So I'll pass you over to Johnny now, who's going to lead off, I think, on goods.
Afternoon, everyone. As Mark said, I think what I want to focus on just for the next few minutes is just, like I say, give you an overview of what the agreement says in relation to a number of areas. And starting off with goods, really, which is one of the areas that's had the most press in recent weeks, and just make sure we're clear exactly what the agreement says in relation to this. So the first point is in relation to tariffs and quotas. And trade between the UK and EU is now tariff and quota free. That was the main achievement by the agreement. But just because it's tariff free doesn't mean it's frictionless. And that's where the issues have arisen. And they've arisen largely because of this requirement for customs declarations. There are increased customs declarations and procedures necessary for the export of goods out of GB, largely. So there is a huge additional now red tape for GB-based businesses in order to get their goods into the EU market. And there is additional red tape as well for them if they want to get their goods into NI now. And the reason for that is the NI protocol. And what that's done is establish that customs declarations and procedures aren't necessary for the import and export of goods between NI and the EU. So for businesses based here, there is little change for them in getting their goods into the EU market. And that friction which GB-based companies are experiencing isn't present here, which is very good. NI companies also have unfettered access, effectively, for their goods into the GB market, but the difficulty comes the other way. So for goods moving from GB to NI, EU customs duties are payable unless the goods are not at risk of onward movement into the EU. And that's where the difficulties are arising, that's where the delays are arising as well as the additional checks on agri-food as well coming into Northern Ireland. And coupled with that are issues in relation to conformity assessments. Now these check that goods meet required standards, and there are issues now in relation to labelling of products, and existing CE marks are no longer valid or soon won't be valid for the GB market. There'll be the UKCA mark instead. And existing certificates which are issued by UK conformity assessors either are going to require a new certificate from an EU-based assessor or a transfer, effectively. And what's important to understand is that it's not just CE marks as well, it's labelling as well there are increased issues with as well, and potentials for disagreements and potentials for disputes, particularly in relation to agri-food. So that's an additional hurdle now, depending on where you're based, which businesses have to comply with, and that's something potentially that will lead to disputes down the line.
Yeah, so Johnny, do you want me to pick up on
of course.
So when we are looking at conformity assessments, it would be important that you really do consider it on behalf of a sectoral analysis, because CE marks may be one aspect of labelling changes that need to be taken into account. And what we found leading up to Brexit, there were lots of requests coming into us from, say, as Johnny pointed out, the agri-food sector or medical device sector, which have different requirements in respect of the labelling and who needs to put what on the labelling. And I think one thing to bear in mind is that there is a lot of guidance out there in terms of what needs to be done. And I think that isn't the starting point necessarily. What we need to do is analyse the law as to why these labels or CE marks or whatever need to be on these particular goods that are being traded. Because what we were often being asked in the context of food, for example, pre-Brexit, is what address needs to be on the label, for example, as opposed to who was responsible for making sure that the correct label was on the address and why, and what would be the implications if this was wrong. So when I point to the difference, for example, between the guidance and the actual legislative position that you are bound by in this sector, yes, if you have a Northern Ireland address on a food label, you arguably have met the guidance that is out there in respect of food labelling, for example. However, the actual legislation is still EU-based regulation, which is in Northern Irish law under the NI protocol, because it is still listed as being applicable in Northern Ireland. And the actual wording states that the address and the entity, the food business operator, must be established in the EU. So the address to be written down must be of an EU FBO that is established in the EU. Now, arguably, a GB entity that has a trading arm in Northern Ireland but no Northern Irish legal presence, if they use that NI address, would not meet the EU regulations and therefore would not reach the conformity requirements for the labelling of that document. That carries across to different aspects, different sectors. For medical devices, in terms of UK responsible person, who is the responsible person? What label are they putting? What markings are they putting on the documents, and why? And the reason why this is important is because we've been very lucky to some extent with how this all came up quite late in the day, and the guidance was quite late in 2020, even into 2021, before businesses were in receipt of it. And there has been various grace periods which have been set aside depending upon your sector or what label we are talking about. But eventually those grace periods will come to an end and we will move into enforcement territory. And the key point then is that question I asked at the start: who is responsible for ensuring that these labels are correct? Because when you're dealing with an enforcement, if they aren't correct, you may find yourself in a situation where you are on the wrong end of a potential criminal prosecution, which you may just say, well, I thought it was going to be someone else down my supply chain who was responsible for putting that label on, which, yes, that may be the case, and they may even be contractually obliged to have done that correctly. But if you haven't checked, or your clients haven't checked that it has in fact been done correctly and it is wrong, and there is an enforcement action, that will come against yourself, your clients, and the fact that it's someone else's fault won't really take you too much further. So there are various grace periods now to ensure these conformities and the right CE marks and labeling are in place, and businesses really should be looking very closely as to what those requirements are and whether they could be in the firing line if something went wrong.
Yeah, that's a very good point. And we'll look at that again at the end, I think, as well, when we look at the opportunities and threats. That point will come up again. I think moving on now just to services as well, because whilst the agreement does cover goods and means that trading goods is tariff-free, the big area which it doesn't cover, which is obviously mentioned in the press as well, is services. Services aren't covered by the agreement. What this means in practice is that from the 1st of January, UK businesses and individuals can't benefit anymore from the freedom to provide services regime, which was an EU or is members of the EU. So they're now not entitled to provide services in an EU member state, except where the host state permits that to take place. Now, what this means is there's now significant uncertainty regarding compliance with regulation in member states, both now immediately, as well as going forward in the future, particularly for regulated sectors. One of the examples we saw in relation to this was in relation to financial services. And there was an example that apparently on the 1st of January, £6 billion worth of trade in EU-based company stocks shifted from London into the EU overnight, £6 billion worth of trade. And it's predicted as well that trade in derivatives is going to move into the EU in 12 months' time, because that has to be conducted in euros and has to be conducted within the EU as well. So that's another service that's going to go as well. And this is a significant issue for businesses. And whilst there is some talk that there may be amendments to the trade agreement, financial services, for example, there may be an agreement on that being on sort of passporting rights being granted by the end of March. There isn't any indication that the EU is close to granting an agreement on that. And frankly, there isn't a huge incentive for them to do so. So we are anticipating there to be more negotiations on the provision of service going forward. But as things stand currently, trade in services is going to be done under WTO rules, and particularly GATS rules. And that means that services can be provided tariff-free. But in order to provide services within EU member states, businesses are going to have to look at the rules in place for each state in turn. And logistically, that's going to be quite complicated now. There isn't a uniform right to provide services there. And that is complicated. But it's increasingly complicated when taken in conjunction with the next point in relation to people and finding how you're actually going to service those contracts. And sort of a quick overview here. In terms of preservation of rights, EU citizens based in the UK will continue to be able to benefit from the rights they enjoyed under the transition period, provided they can demonstrate that they were residing lawfully in the UK at the end of the transition period. There are now new immigration rules in the UK, and it's become a points-based system for all non-UK nationals. And this means it may be likely, in terms of work visas, it will be easier to sponsor non-UK nationals as new hires, potentially going forward. There is, of course, the EU settlement scheme for EU nationals in the UK, and the deadline to apply for that is the 30th of June 2021. So that people can still apply for that, and it's important to make that clear, but the deadline is fast approaching. But the key issue in relation to the changes brought about are British citizens working in the EU. And as I said, they are now required to comply with national requirements to reside and work in that member state, which means work permits, visas, and residence permits are going to be required for providing services within the EU. And that's where the real difficulty lies and the real logistical headache for businesses lies. There are some workarounds and the potential solutions in place, But there is, there are also under the agreement a provision to provide 90 days services within any 180-day period within the EU, but that only applies to certain business services. In reality, that really means attending meetings in the EU. It doesn't mean going into the country and providing services for a period of time. If companies are required their workers to do that, they will need to look at the rules in relation to each EU country and how they do that. And that's a significant change, particularly for businesses here in NI who do send their workers into the EU. They are now having to look at how that works going forward. And it's going to be very challenging for them.
I mean, I think just to add to that, to emphasize it, Johnny, I think if you look at that slide, the sort of 4 points that arc over the one at the bottom and the middle, they're all about people coming to and living in the UK, which was a big focus in the Brexit agenda in GB about control of the borders and immigration, which that has all been focused on. That's what a lot of the conversation was about pre 31st of December, but the one in the middle at the bottom is critical. I mean, if you are a service provider with a client base in Europe, there's 27 sets of rules you need to understand now to be able to put your people into those jurisdictions to deliver services. And that is ultimately for your clients. If you've got a client in that service sector that have people traveling into Europe, they have to look at the options and get a functional workaround for how they're going to address that and make that manageable.
Yeah, I think that's the key point. That's the key point for businesses to understand. Moving on to the next section now, I'll pass you back to Micaela in terms of competition and how that's changed.
Thanks, Johnny. Okay, so when we're talking about competition law today, I'm going to look at it firstly in the purest competition law perspective, anti-competitive agreements, abusive dominance and merger control on one side, and then what we now know as subsidy control or state aid rules on the other side. So from the perspective of the first, competition law has been in the UK law, driven from EU-based law, and it is virtually the same subject to some geographical differences. And this is the same pre-Brexit, and it is basically the same now post-Brexit. There were some legislative changes that were taken into account, but these are more administrative as opposed to substantive. But it is the differences on the ground that we are going to see. So arguably, as we speak today, EU competition law does not now apply in the UK. But what we will have is a UK regulator who will be looking at issues that maybe sometimes otherwise the EU would have been looking at without the UK stepping in. So we may have a situation where we have simultaneous issues of competition law before an EU regulator and a UK regulator for businesses, whether that's in the context of merge control or a cartel investigation. So if you are a business or have a business client who is subject to issues of competition law, you may now see an increased regulatory burden, extra time, extra resource, just to deal with competition law matters in the UK that will also engage the EU. If you haven't yet had cases where you have had involvement with the CMA, you will going forward. I think that is inevitable. It's inevitable for two reasons, because of what I've just said about the increased presence of UK regulators in law in the UK, but also because the CMA has increasingly become interventionist in their approach and have shown a willingness to get involved in UK-based competition law matters. I'm going to put a point out there because Mark, you might want to comment on it again, but realistically, the whole trading relationship of the UK and Northern Ireland in particular, given our relationship with the EU, is probably going to be a special context the CMA is going to be interested in. So I think from that basis that we probably will see quite an increased role of the CMA, but on that point in particular, does this mean that EU competition law doesn't apply in the UK at all? No. The rules as to when EU competition law applies is when there is an effect on trade between member states. So if you are a GB or an NI entity that continues to trade with the EU, you will still have to take into account EU law as well as UK law. I mentioned that separate to competition law, we have state aid law. Unlike competition law, there was no previous UK presence in law of state aid. It was a purely EU measure, which is one of the reasons why we saw it negotiated right up until the end of the Brexit negotiations, and it's now being termed as subsidy control. And because it was a very last minute feature of the TCA and the position on it, it's a little bit unclear at this point what impact this is going to have post-Brexit. But one thing is clear, or supposedly clear, under Article 10 of the NI Protocol, is that EU state aid rules will continue to apply in Northern Ireland in relation to the trade of goods. That sounds fairly simple, but what you have a situation of, it is not either or. You now need to have compliance with EU state aid rules and UK subsidy control. It's also then further complicated for a few different reasons, because within that, you'll see various guidance out there from UK Cabinet Office outlining and BES saying, you know, there's more freedom now for state aid in the context of services. But you compare that to the guidance which the EU have set out for their stakeholders, and it maybe is a little bit unclear. And actually, what they have said, the actual EU guidance says that EU law, state aid law, will still apply to public support for any economic activity that is liable to affect relevant trade. And they actually provide an example of potential of incentives that will be given to the financial services industry that would allow manufacturers who are engaged in trade between Northern Ireland and the EU to access cheaper credit. And it makes those manufacturers therefore have a competitive advantage over their trading partners in the EU. So this whole limitation to trade only is slowly being grey, that area between what is black and white between trade and services. And it is going to create issues going forward. It was something that was negotiated to the end because it was a big issue. And it's clear from the divergence in the guidance so far that those issues and those potential for reach back provisions that we now see in subsidy control will be a problem going forward.
Yeah, I think if I just make one comment on that, Micaela, I think, which is historically, those of us in the call of a certain age, I'm certainly one of them, is that competition law hasn't been a massive factor in our practice life, really, because the numbers in Northern Ireland don't get near the thresholds for needing to go to the competition authorities generally. However, what we're conscious of now is that no one really knows how the protocol is going to work and how Brexit is going to work. And if the protocol works not just well, but too well for Northern Ireland, then we're in the same way we'll see in the opportunities and threats piece, we will be looking at how we leverage it, but your clients, competitors in other jurisdictions will be looking at, can they leverage the protocol as well, which may drive either M&A activity in Northern Ireland or establishment activity in Northern Ireland, or maybe the success of the protocol will be due to initiatives taken by the Westminster government. But either way, a tool that will be used by Europe to stop us doing too well in Northern Ireland will be competition and state aid. So when you're working through with your clients how to consider Brexit, what opportunities are and what they're going to do, you do need to have on your checklist what are the competition issues. And again, it is for us as professionals, I think we haven't been through these rules every day of our lives. There's thresholds, there's market analysis and so on and so forth. And the cost of referrals to the CMA and the cost of having to maybe unwind a transaction that's not approved after the fact is really significant. So it's one to make sure clients who are looking at these opportunities think about the competition and state aid aspects first before they're sinking too much of their hard-earned cash into projects.
Agreed.
Okay, just before I move on to the next topic, which is IP, I see we've just got a question in through the Q&A from Pauline Flynn, just asking how are individual workers residing in NI but working in ROI impacted? What do they need to change? The answer is that they don't need to change anything if they're UK or Irish nationals. The Common Travel Area is preserved, the right to move freely under the Good Friday Agreement. That's preserved. That's not impacted by the protocol. So they don't need to do anything. Nothing changes for them, provided they are either UK or Irish nationals. Okay, just moving on to the next topic. The last two topics, IP and data, I'm just going to do very quickly because not a huge amount has changed in relation to those. In relation to IP, in terms of trademarks, EU trademarks, EU TMs no longer have effect in the UK, but the UK government has automatically created comparable UK trademarks for every registered EU TM at no charge, with effect from the end of the transition period. The same concept applies for design rights. A similar sort of equivalent rights been granted now in the UK register to existing rights. And in relation to patents, there's no real change in relation to patents. Patents covering the UK will continue to be granted by both the UK IPO and the European Patent Office, and existing patents remain in effect. Just quickly in relation to data, this was something in the event of a no-deal Brexit, there were concerns that this would change, and it would have changed, but what has happened effectively is that currently the EU is considering whether to grant the UK an adequacy decision, which basically means that the UK data protection regime is adequate, so data can flow freely from the UK to the EU. Whilst that's ongoing, the temporary arrangements in place under the transition period remain in place, so data can continue to flow freely between the UK and the EU, and there are no restrictions during the first 4 months of the year, which is potentially extendable to 6 months. So you don't need to do anything now in relation to data transfers. There's no need to put in place standard contractual clauses, which there would have been in the event of a no-deal Brexit. It's anticipated that we will get an adequacy decision, but it's just something to monitor in case it doesn't come through, in which case there will need to be put in place transfer mechanisms between the EU and the UK if data is going to flow between them. But at the minute, nothing needs to be done. So that's a whistle-stop tour through just sort of what has changed and just highlighting the key things that have changed now under the agreement. But what we want to focus on at the end of the presentation now is sort of looking at opportunities and threats. And I think the way, as Mark said, we want to structure this is in starting off by looking at supply of goods.
Yeah, and I think, Johnny, just before you close out the data point, I think I'd maybe just say to the audience, from my days working with PwC in Belfast, I love the phrase that inheritance tax is a voluntary tax. If you plan properly, you don't have to pay it. You will find there's a lot of noise about data around Brexit, and there's a lot of effort being put into making it sound really complex. The professional advisors can kind of earn their money, which is fair enough. However, clients should not be spooked by it. When we come through the opportunities and threats piece, data is entirely manageable, but it's important to get it right. The ICO generally is not out to give people trouble. They just want you to be compliant. So if you take the steps to comply and go through the process of making sure your data is managed appropriately in the new dispensation, you're not going to have any massive penalties kicking in, but they do need to do it. Ignoring it or pretending it's not there is not really an option for the client. So they do need to make sure that they've kind of considered it as part of their post-Brexit business reviews. So this is the final section of the formal presentation, and what we've tried to do here is, I mean, we've talked through quite a lot of stuff there on issues that are emerging from the structure of both the free trade agreement and the protocol. Much of it you may have seen before. We were just trying to pick out what we thought were the highlights. This section is about just trying to apply a bit of legal commercial knowledge to it and say, right, so what does that all mean? How should we be using this knowledge for our clients so that we can help them and obviously give them good service? So we're doing 2 slides coming up now, one on the supply of goods model, one on the supply of services. You'll know which of your clients fall into which group. Some of us will be doing a blend of both goods and services. And there's a similarity about how you process the business and think it through. So, I mean, if we maybe start with the supply of goods, that'll give you a sense of where we're going. And we would encourage you, there's 2 slides here before we get into the conclusion. So if you've got questions around this, we're very happy for it to be as interactive as you want. So just as questions arrive, do throw them into the question section.
Okay, so I think the obvious, I'll start with a threat, Johnny, and then you can maybe take it a bit more positive. So getting goods into Northern Ireland from the GB, I think you only have to look as far as the numerous daily news reports as to those issues and how there are issues in doing that for businesses. And it is something that is a result of Brexit. It's a result of the new regulatory systems that are in place, and the fact that everyone, including the supply chain themselves, as well as enforcement and customs officials and government authorities, because bear in mind, in the same way that businesses didn't have a huge amount of time to have clarity on how they would prepare and deal with these issues, the same also applied to the government side of the house in terms of the negotiations running so late in the day. So this is really going to be one of the massive threats that you're going to face. Hopefully, if we can maybe throw up some opportunities and innovative ideas that businesses can maybe do to help offset these threats, that might be worthwhile. And I think, without going into this into too much detail, we may touch on that as we go through, but if there's anything else on that point that Mark, yourself and Johnny want to look at, then we can.
No, sure. I think that then links over to sort of the first opportunity as we see it, because obviously that's the clear threat, that's the clear difficulty, is how you're going to get the goods into NI from GB. But the opportunity flowing from that is that there is a strategic advantage to the businesses which solve this issue first, which can work out how they can alleviate that. And what that solution is, it's going to be different for every business, because the impact's going to be different for them. But where the opportunity and where the solution really starts, as we see it, is by sort of analysing and potentially refreshing the business's supply chain, looking at, where do goods come into at the minute in their supply chain? What comes in from GB? What has been coming in? How has that supply chain changed so far this year? Have there been increased delays? Have there been increased costs? Who's picking those up? Who's responsible for them? Is that agreed? Is it not agreed? Maybe the contract doesn't cover it. Maybe it's silent on that, and that's potentially leading to disputes. So it's really looking at the extent to which you can refresh your supply chain. And if you've been using GB suppliers, it may be now time to think about switching that and switching to an EU supplier if you can, if that works for the business.
Yeah. Sorry, Johnny, go ahead.
No. I was going to say, and that's really where we talk about, we're looking at sort of the protocol comes into effect, and that's the real opportunity is looking at the supply chain, really analysing it, looking at where goods come in, looking at what the contracts say. But then that leads to another threat. I think kind of
exactly. I mean, that opportunity has the flip side of the coin being the threat. What do the contracts say? Do they provide for offsetting some of these risks? I mean, I touched on some of those risks earlier in respect of conformity requirements. Do you have contracts with your supply chain which ensure that if the conformity processes and assessment and labeling and customs processes and forms and everything, if they're not completed in the way that they should be, what does your contract or your client's contract say about that? Who's going to bear the costs of it? What is the role of the logistics company? And importantly, for yourself and everyone within the supply chain, because it would be important to know who you're dealing with, that they also, as well as your clients, have the appropriate insurances in place. And do those insurances cover off some of those risks that we see in respect of getting goods into Northern Ireland from GB? Do they cover issues such as delay? I mean, again, different sectors will have different requirements. The fast-moving consumer goods sector is going to have huge consequences if there's any delay in getting goods across to where their destination is. And if we have a situation where you have a lorry load of meat that has past its use-by date, you're hardly going to have a retailer on the other end who's going to accept it. And they're not going to care whether the delay was caused by customs officials or whoever it might be, if they have contractually said to you, that is your responsibility. And we're going to see litigation, maybe not just in the supply chain, but also in respect of insurers disclaiming if forms haven't been filled out properly, that then led to the delay in the first place. Which then, I suppose, is then onto adverse regulatory decisions would be the next threat that sort of comes across that as well. I mean, government officials are looking at these forms newly for the first time. They're getting their, you hear about the vets and not the appropriate number of vets there to make the relevant sign off. And there will be, Mark, you referenced eggs or mini eggs as they may be that were, held back that shouldn't have been. So there are going to be mistakes made that by the regulators in terms of how they take their decisions. Some are going to be blatant mistakes, but some are just going to be an incorrect interpretation as to what the guidance says, and there will be a dispute between the business and the regulator as to why a particular tax or customs tariff or delay in goods is being taken forward. So depending upon the outcome of that adverse regulatory decision, there may either be something which incites businesses to enter into litigation to challenge that decision, or they may have no choice. If they have found themselves on the wrong side of an enforcement action, which is ultimately a criminal prosecution, they may have no choice but to defend that action. So you really need to make sure that your clients fully understand the regulatory framework they're operating in for their sector.
Yeah, no, I think that's exactly the issue. And as I said, I think looking at making sure they understand what they're covered for under their insurance is key, and to the extent to which you're covered. And that's important to have that understanding now in advance. I think just going down the opportunities there, it is important to understand that, NI-based businesses do have easier EU access than GB manufacturers. And that could be key going forward. And that does present opportunities. And it's important that those opportunities are maximized and that they are grasped, because, there is potentially, opportunities arising now, which weren't available previously, or GB-based businesses which can't supply to the EU market or are facing significant delays. So there are opportunities there which are presenting themselves. And it's important that businesses are aware of those and alive to those and are exploring those now as well. And I think, that goes hand in hand with the final bullet point on the opportunities, that the importance of doing a strategic review now for the business of the opportunities presented by the NI protocol, what they give, the opportunities to potentially diversify the business into other areas, whether they can do that. And I think, it is important to be proactive in relation to that for businesses, that they are assessing that and seeing what opportunities are arising, and then they move quickly in relation to those.
And then in respect of loss of European rights, that is unfortunately just the reality of Brexit. That was what Brexit created, a removal from the single market, or removal of some of those rights that we would have otherwise have had. There is no recourse really to reassert those rights now that we are in a post-Brexit scenario. The ability to pivot as a business and to find innovative ways that Johnny's been touching on in terms of overcoming a situation to make up for those loss of rights is just something businesses are going to have to look at. It was the reality of Brexit.
I think I think we should get to the end of that list. My reflection would be, whenever we were preparing the slides, we were thinking, how could we best assist you guys with using the current position to design a route map for your clients. And I think the logic is, if you kind of, clients we find very receptive of contact calls at the minute, because people are locked down, and therefore sort of taking them through that sort of train of thought, where's their snags? It's the GB to NI corridor. How can they fix that? How can they leverage that? If you've got a client that's having an issue with they can't get a key component supplied in from GB, then they're at risk of getting sued by their customer, and they've probably got cause to terminate or vary their agreement with their GB supplier, because they may well be in risk in breach of their agreements. So it's a perfect time to refresh the supply chain. And if you've got a foot in both the European and the GB market, and you're in Northern Ireland, can you reshape that supply chain to do EU on EU and GB on NI, so that you will not have the supply chain problems if you're bringing stuff into Northern Ireland from EU and you're manufacturing goods? I think, again, this is very live at the moment, so it's very timely for you to call your clients at the moment. Johnny flagged the business insurances point. I think if you're just rolling over your old insurance and haven't talked to your brokers, rest assured the clients will be not getting the premium position. If you have to sue someone for breach of a supply agreement, or because your goods are stuck on a dock, you want to make sure your insurance is going to cover that cost, because it'll be quite onerous to fund that insurance while keeping the day job going forward. So that opportunity at the minute is very live and very present for your clients. It's a good excuse, a good touch point to be phoning clients now and saying, how are you getting on with Brexit? What's it look like? Have you thought about the following things? I see there's a question that's come into the Q&A section while we were talking on that slide. and it's from a chap or a lady, Johnny, sorry, Andrews is saying, is the NI executive still constrained from reducing taxes under state rules, it's e.g. in the event of devolution of corporation tax? So I think that's been triggered by Micaela's state aid question. I think my view on that, Micaela, before I'll leave you to kind of comment on it, is probably that, as I recall, the Azores principle, and again, this is kind of me preaching to the choir a little bit. You guys know more about the tax than us, but provided the tax rate reduction is not subsidized by Westminster, then it should not be stated. If it was costing us, if we were getting underwritten by Westminster for a corporation tax deduction, then I think you would get into trouble with stated rules. But the whole principle behind the scheme originally was that we in Northern Ireland were carrying the risk of it not working, and provided that remains the situation, I wouldn't anticipate there being any fundamental change brought about by Brexit on that. I just think the political appetite for it may be less strong.
Yeah, in terms of whether or not it gets brought in, or how that works in an internal market perspective, yeah, that's probably correct, Mark, in terms of it getting across the and the potential for it coming live. In terms, though, of the constraints and whether or not it will be deemed under the UK subsidy regime, or if it will be deemed also under the EU state aid rules, it goes back to that point I made earlier. If we look at a strict interpretation under the NI protocol and Article 10, it states that EU state aid rules will only apply to goods. We're talking about taxes in both of these instances. So first port of call would be to say no, that EU state aid rules shouldn't apply, and we just need to make sure that there's conformance with subsidy control regime and that it all works between Westminster and Stormont as Mark had intended, had spoken about. But then you think about the guidance that I've mentioned that has been issued by the European Commission, the new stakeholder guidance, which spreads its wings into what impact on trade of goods actually means. And can we have a situation where the devolution of a corporation tax provides a benefit to our manufacturing industry so that they can trade their goods on an EU market in a more advantageous manner than their EU counterparts? Arguably, there is a potential that the EU could assert that state aid rules would apply. I would imagine that the UK and NI governments will push hard against that. And this is one of those things where I think that there will be litigation on. There will be issues going forward between EU and UK on these types of high profile issues. It may not be businesses and services firms taking this litigation forward, but I think this is just sort of very, very sort of big, huge, important issues that the EU and the UK still haven't bottomed out between where the boundaries are for the application of EU state aid law. So simple answer is no, it shouldn't. The complex answer is I think there's a chance the EU will assert it.
Agreed. Johnny, I'm conscious of time. Should we skip on to the supplier services slide?
Sure.
And again, I think it's the same but different as the previous one. It's trying to just analyze the opportunity presented for you guys to talk to clients if they're in the service sector around the sort of manufacturing goods. So again, I think similar starting point, Micaela, with the threats, really, isn't it?
Yeah. I mean, it goes back, and it's one of those ones where Johnny's going to answer the threats through an opportunity, but getting staff into the EU territory to fulfill the work that you would otherwise have done in the service industry, the business is going to need to find innovative ways to work around that. And the same way in a goods perspective, you need to look at your supply chain, you need to look at your mechanisms for how you deliver services to overcome that threat.
Yeah, and I think clearly, again, as with the goods position, there's a strategic advantage for your clients if they can solve the issue first. And that's about refreshing their business model, revisiting it. How do they do it? How do they currently service it? So again, we're looking at one case at the minute where there's a bit of design work done in Northern Ireland, but then they put in a team to go in and deliver a solution physically on the ground in Europe. And that, with the current Brexit regime, is challenging without engaging in various visa requirements in the jurisdictions that they work. So there's a risk for that client that ultimately they find themselves in breach of contract if they can't perform due to inability to get people in country.
Okay. Do you want me to have a look at the,
Yeah.
the litigation risk again?
So the litigation consequence, Micaela, is?
Well, actually, I was going to flip it on its head, because we've covered off litigation risk in the context of what businesses may do, and they may find themselves, may not want to have the deep pockets to go on inexpensive, very expensive litigation challenges. So I'm going to flip this now and consider this from a different angle, where as a result of services post-Brexit, businesses find themselves inadvertently caught up in litigation. And the context of that is where we're talking about public sector work, procurement work, whether that is public sector work won either in an EU 27 state or if it's in GB, and you have a challenge from an outsider that may state, say you or your business have been successful in winning that contract. Someone may take a challenge against that, that contract award because you don't have the relevant service requirements that you need to, or they may suspect that as a UK, GB, NI-based entity, you don't have the relevant insurances, if you're financial services passporting, if you're a lawyer, practicing certificates, those types of things that, for you to win that contract. So you may find yourselves caught up in the risk of litigation inadvertently, and it may become very, very problematic for you to prove through an expensive procurement case that you actually do have the correct approvals and accreditations and licenses to carry out work in that sector. And businesses, if you are participating in a public sector bidding work, either within the UK or abroad, that you need to make sure that you can fulfill all of those requirements very, very clearly to ensure that you don't fall foul of that risk.
I mean, a good example of that, Micaela, which is relevant to us, is ensuring when we're giving legal advice to clients that our qualification as lawyers is recognised in the jurisdiction in question. So obviously you'll be aware of the concept of privilege. So if we give advice to one of your clients about the risk of a particular case, privileged advice cannot be disclosed in court, or they can't seek disclosure of it. However, if you're doing that from Northern Ireland into a French client and you haven't got recognition of your qualification and status in France, then that privilege may be forfeit, and that could have catastrophic consequences in the client's case when you're saying it's a lost cause, we'll try to negotiate, for example. So again, I would have thought for service clients this year, if their business insurances aren't going up this year, they really need to have a good look at them, because whilst our smaller SME economy may not have had the time or resources to really focus on Brexit consequences for them, the big insurance companies have been all over this for the last 3 or 4 years, and policies will be modified and changed to make sure they're not exposed on that sort of litigation risk or adverse regulatory decision kind of ongoing when they're looking at PI cover and business interruption insurance and that kind of piece. So that's a key piece to be communicating to your client base. I think you've got sort of European rights, Micaela, it's kind of the same principle, really. It's really live here with the kind of loss of freedom of movement of people, which I suppose, sort of going back to the opportunities, I mean, this is the key piece, I think, for the conversations you're going to have with your clients. We are in a unique position in Northern Ireland. We're on an all-island economy. We've got a common land border. We got the common travel arrangements in place, so we can move freely, and we also have the benefit of the protocol east-west as well, or west to east. Sorry. So actually, there's a lot to recommend Northern Ireland as a key part of anybody's European strategy. So it's again a key point for your clients to be just considering and reassessing how they do business, both with GB and with the European market. Are you want to talk about the sort of the FTA piece, Micaela, or?
I'm reading the question at the same time, but I'll cover the FTA and then we'll move on to the question. Yeah, I mean, it took how long to get the goods piece and the FTA up and running, and the services aspect. I mean, you only have to look at the ongoing constant debate about financial services in London. It's a long road for the EU and the UK to have come so far, and they've only taken it as far as goods. are they really going to be negotiating an FTA in respective services in the short term? It seems unlikely that would be there. We've still got a lot of issues that need to be worked out on what has been negotiated and to go back and forth on yet. And I think that is going to consume the attention for the foreseeable future.
Mm-hmm. I mean, I think the question from Pauline's actually quite timely. It's an very interesting point. It kind of takes into sort of the last bullet on the opportunities really, which is, and the question is that where there's a parent charity and NI providing all the back office and management support for their ROI subsidiary charity, delivering public sector contracts in ROI, what do they need to do to deliver those support services contractually and effectively in the Republic? So we've got 2 or 3 live cases in this at the minute where there are a couple of workarounds at the minute as to how one might sort it, but certainly what's standing out there is the fact you've already got a subsidiary in the south, so you're incorporated in the jurisdiction. You've contracted through the Irish subsidiary, so those are 2 helpful points. What we've seen again in other sectors is that the European response to trying to work on the fly cross-border is being controlled by the requirement for establishment in the in a European jurisdiction to avail of the European benefits. So I think the fact that you have an actual presence there is probably helpful. It also helps if you've got some employees in the ROI subsidiary and an ROI charitable registration. So there'd be quite a lot of detail around that. So you should be able to structure it in the way that works, and it may be a secondment arrangement or a management charge. But again, it's worth exploring that to get it right, given that you're a charity and you don't want to be the wrong side of negative publicity if there's an issue. And I suppose that tees it up perfectly. So thank you for the question. The last bullet point: there's just simplicity about moving to within the EU. So at the minute, our colleagues in Europe and further beyond are considering, is there merit in establishment or acquiring something in Northern Ireland to facilitate their business, because they think there's an advantage potentially in leveraging the protocol for their businesses. If you think about what's causing the problems for services and supply of services into Europe, it's all about the loss of EU rights, the basic principles: freedom of movement, freedom to establish, recognition of qualifications, etc., etc. So the easiest way of actually resolving that is to look at whether or not that particular client should have an EU presence. And again, you'll have seen in the press that there are stories of significant activity from Holland and others to court businesses, and certainly there's in GB, and I'm very much on the East Coast, as being Holland should be the place to migrate your distribution hub, whether it's a factory or a distribution hub. That seems to be a very active line of activity, and it remains to be seen the longer term impact that might have on how much of the British economic activity remains in the GB island, because whilst it may still be the same business, you're looking at subsidiaries coming into existence. Johnny, do you want to just go to the last slide maybe, and we can sort of talk through the concluding thoughts and then take questions as required. I mean, I think clearly we're going to be dealing with Brexit for many years. It took them 4 years to do one deal on goods. That's being modified as we speak. And again, Micaela referenced it already. There was talk of a deal on services, but if the net effect of that is that our service economy starts to establish within the European group of countries, to manage the 27 sets of regulation, the VAT issue, all of those things will be picked up if you've got a business operating within the EU. It's inevitable that Europe will not rush to agree that, because they will benefit in the short term and the long term from not having a decent agreement on that for UK-based businesses. Regulatory divergence is going to come down the track again, so it will be more challenging to keep on top of it. It may become a tool of partisan governments to try to manage the position for Northern Ireland one way or t'other. So again, I think our clients do need to be just live to that being likely in their sector. Generally, we find they know their sectors very well in any event. It's just they can't stop thinking about Europe if they're straddling the border. There's a risk on the Northern Ireland protocol being collapsed. So you'll probably pick that up in the earlier press correspondence, which was that in 4 years' time, there's a popular vote to see if we still want to keep it. So, what would have potentially been a really good investment opportunity has a question mark, I'm sure, for some FDI candidates thinking, will it be okay if we spend a lot of money? Are we still going to be benefiting from those things in year 5? So there's going to be a political element to this, and the sooner business is able to get stuck in and see what they can, what advantage they can make of the protocol, the better, because we don't think government solutions or recommendations are going to be particularly fast. And if you're waiting to follow government advice, the opportunity that exists at the present time may well have passed. So again, we are encouraging proactivity from our client base at the minute, and I suggest that's something you can be doing as well. There obviously is a thought of quite a significant cost, perhaps, in taking tax, legal, accounting, all that sort of advice, but there's actually very good support available at the minute from Invest Northern Ireland. The numbers we've seen on some of the cases we're working are not to be sniffed at. So again, if your clients aren't aware of the support they can get, we've seen mandates of 15, 30, 45 grand of total fees subsidized to the tune of 50% to actually work out how to reshape the business model for a particular customer. I think that is something that if your clients are going to be adversely affected, they really need to be working through what they might want to do and getting the Invest and I support that's available to get the requisite advice. And the final point there really is, with the UK having moved out, is it going to be the consequence that actually Northern Ireland and GB business move into Europe again? It seems quite inevitable, because when you analyse the pluses and minuses, the problems and the opportunities, the best way of mitigating a lot of the problems at the minute is to have some sort of presence that you can funnel your business through Europe, a European operation. I think that's probably us, unless Micaela or Johnny have anything further they want to add at this stage. But we have a bit of time left, so I'm more than happy to sort of field any questions if you'd like to do so.
One question there, Mark, that has come in. If it's inevitable that there will be litigation arising out of Brexit, where do you think these challenges are going to come from?
That's me, really, isn't it? Being litigation. It's very difficult to say definitively where the challenges are going to come from, because it will depend as to what is happening on the ground for particular businesses, what they see as particular pinch points, and how important it is for them to take it forward. Now, the issue that appears to be in the headlines, as we see, is the delays at the borders, and it is going to be affecting the likes of the fast-moving consumer group industries first. But to take litigation forward of this nature, of such constitutional importance, with such complexities as Brexit, is going to require seriously deep pockets. I'm not sure that individual businesses will want to take that risk, and if that is going to be let out, it will probably be done by umbrella bodies or trade associations and the like. So that's the possibility, but I think inevitably, and I think it's only a matter of time before we start to see 3 other areas I think will really, really see the focus of litigation. Obvious one being tax and customs. The second one will be procurement, not only because procurement is hotly contested in Northern Ireland in any event. Now with the changes, I think it's going to be even more so. And then I think some of the questions have touched on it here today. Negotiations went right to the end for a reason. Subsidy control and state aid, that is going to be another area. That's where I'm thinking anyway.
And I think supply chain as well, Zara, would be the situation where your customer suffers a loss, you haven't delivered, they'll seek to recover it from your insurance. And then if the fault is not yours, but it's your supplier, you're going to have a supply chain case, which has probably got a couple of insurers involved, and that could be time consuming. And absent insurance, I would agree with Micaela's analysis that you're looking at maybe industry bodies challenging policy or procedure and so forth. But in terms of when you've got trading parties who are actually live in business, when there's insurance in place even for one party, suddenly you can find the writs start flying, because it's easier to do that than absorb the loss yourself.
Great, thank you. And another question that's just come in: who will be participating in the referendum in 4 years on retaining the NI protocol?
As I understand it, Johnny may be a bit fresher, but as I understand it, effectively it's the popular vote will link to the assembly vote at that point. Isn't that right, Johnny?
Yeah, the assembly make the decision as to whether or not it gets maintained. So I think for the next elections we have, that may be a live issue. But it's, as currently stands, it's not supposed to be another referendum in 4 years' time. It's just that they have the ability after 4 years to say we no longer wish to be part of it, but that'll have to come down to a vote in the Assembly, and they'll have to vote on a majority basis.
Majority vote. So I think at the next election it'll be very important who's sitting in Stormont, because 50+1 kind of is quite important.
Great. Those are all the questions that we have got in, and we are just about out of time. So I would like to thank you, Mark, Micaela and Johnny, for your time today. You've certainly given us lots of food for thought, and plenty of tips to take away to look at, both, I suppose, in our own businesses and in those of our clients. I think the key one for me there was to check the insurance, and I anticipate we're all expecting big increases in the insurance when it comes in then. So thanks again, and stay safe, everyone. I hope you all have a lovely afternoon.
Thank you.
Thank you very much, everyone.
Thank you.